Here we observe that the present matter is a classic example as to how the nexus between the politicians, bureaucrats, and the in the conversion of precious forest land for commercial purposes under the garb of resettlement of people belonging to the backward class from whose ancestors agricultural land was acquired for public purposes. We have framed the issues. The first issue is as to whether the subject land is a forest land. Just giving a gist, a perusal of the Gazette notification dated 1st March 1879 would reveal that it declares the lands described in the schedule annexed thereto to be reserved forests in the Pune Collectorate. The said notification has been issued in exercise of the powers conferred by Section 34 of Indian Forest Act 1878. A perusal of the schedule thereto would reveal that the land in village Kundwa, Budruk, having survey number 20, and measuring an area of 32 acres, 35 guntas, has been included in the said schedule. Subsequently, by way of notification issued on 5th of January 1934, it was declared that out of the said area in survey number 20, an area advisory 3 acres and 20 guntas would cease to be reserved forest. As such, after deforestation of 3 acres and 20 guntas, the balance area of 29 acres and 15 guntas, that is the subject land, continued to be notified as a reserved forest. We have therefore answered the first issue in the affirmative. The second issue is as to whether the Divisional Commissioner was justified in recommending the allotment of subject land in favor of Chauhan family, and as to whether the state government was justified in accepting the said recommendation. We have considered the material on record. We have observed that having held that the subject land is a reserved forest land, and during 1960s, different parcels of land in survey number 37 of Kundwa Budruk belonging to one Chauhan family was acquired by the state government for the purpose of construction of a hospital. On 13 May 1968, the subject land was released to the Chauhan family for cultivation for a period of 1 year. The subject land was allotted on an ek sali yearly basis for the year 1968-69. The said ek sali lease was, however, never renewed thereafter. While accepting the said yearly lease, the Chauhan family has given an undertaking that they will hand over the vacant land, vacant and peaceful possession prior to 1980. On 25th of October 1980, the Forest Conservation Act 1980 came into force. While relying on Section 2 of the said Act as it stood then, as per which no government or any other authority, unless there is a prior approval by the central government, would have directed any reserved forest or any portion thereof to cease to be under the status of reserved or any forest land or any portion thereof to be used for any forest purposes, nor could it have assigned any forest land or any portion thereof by of lease or otherwise to any private person or to any authority, corporation, agency, or any other organization. We have further relied on the judgments of this court, the case of Ambika Quarry Works versus State of Gujarat and others, and the order of this court dated 12th December 1986 in the present proceedings. We have distinguished the judgment of this court in the case of State of Bihar versus Venturam Modi and others, which was relied on by the Rich Cooperative Housing Society, inasmuch as there was no order permitting the subject land to be used for non-forest purposes by any of the competent authority. We also place reliance on the judgment of this court in Nature Lovers Movement versus State of Kerala. In any case, nothing is placed on record to show that the land was permitted to be used by the state for any non-forest purposes prior to 1980. Since the cease lease was valid only for 1 year after 1980 Forest Conservation Act came into effect, in view of the restrictions imposed in Clause 3 of Section 2 of the 1980 FC Act, the forest land could not have been assigned either by a lease or any other mode to any private person unless there was prior approval of the central government. Therefore, so far as the second issue is concerned, come to the conclusion that the decision of the state government of allotting the land and implementing the same by the collector is not at all sustainable in law. That view of the matter, we have no hesitation in holding the allotment of the land in favor of Chavan family by orders dated 4th of August 1998 and 28th of August 1998 is not sustainable in law. Third issue that we have framed is as to whether the doctrine of destitute would be applicable to the facts of present case. It was sought to be contended on behalf of the RRCHS that though the subject land was shown as a resort forest land, as far as back in 1879 ceased to be the resort forest land. We failed to appreciate such a submission. In this regard, we have relied on the judgment of this court in the case of Monnet Ispat and Energy Limited versus Union of India and others. You find that the legislative history would clearly show that right from 1878, when the Indian Forest Act 1878 was enacted under Section 34 of the said Act, the law with regard to protection and conservation of forests has been consistently evolving more and more in favor of protection of forests. We have therefore come to the conclusion that the notification dated 1st of March 1879, issued under Section 34 of the 1870 Act, has been put to disuse for a long time. In any case, nothing has been brought on record to show that a practice contrary to the provisions of the said Act was being applied. In that view of the matter, such an argument has to be heard only to be rejected. Both issues as to whether the RRCHS would be said to be a bona fide purchaser of the subject land. It was sought to be urged on behalf of the RRCHS and that they are bona fide purchasers of the subject land in question. It was further submitted that even the revenue record pertaining to the subject land had shown the possession of the Chavan family over the said land. It was therefore submitted that the RRCHS, which is a bona fide purchaser of the land in question, would not be faulted with and penalized for no fault of theirs. We relied on the judgment of this court in the cases of Suraj Pan and others versus Financial Commission and P. Kishore Kumar versus Vittal P. Patkar to reject the said submission, inasmuch as it is well settled law that the entries in the revenue record do not confer any title to the property. We further reject the submission of the Richie Rich Cooperative Housing Society in light of the glaring facts in the present case. It is aptly clear that though the Exali lease expired in 1969, members of the Chavan family were silent for a period of almost 20 years. Things started moving only in 1988. During the said period, much before the allotment could be done, the members of the Chavan family had already started negotiating the deals with Mr. Aniruddha P. Deshpande, not Kulkarni, the chief promoter of RRCHS, and Mr. Rajesh Shah. The files were moving at different levels from 1991 to 1998, culminating in the final allotment in the year 1998. In the meantime, all the development rights in the land already stood transferred either to Mr. Aniruddha P. Deshpande, the chief promoter of the RRCH, or to Mr. Rajesh Shah. For the said purpose, not only had some of the members of the Chavan family entered into development agreements, but they are also executed a power of attorney in favor of said Mr. Aniruddha P. Deshpande, surrendering their entire rights in his favor. In that view of the matter, we find no substance in the argument that the RRCHS was a bona fide purchaser of the subject land. Facts point out that the Chavan family was only set up as a front for the benefit of the developers. The fact that the agricultural land of the Chavan family was acquired was being misused by the developers as a pretext for grabbing the valuable piece of forest land for the purposes of commercial development. For doing so, even the status of a person who belongs to backward class was being misused. The fifth issue that we have framed is as to whether the RRCHS would be entitled to allotment of alternate piece of land in view of the orders passed by this court in regarding construction of multi-story buildings in forest lands in Maharashtra. An alternative submission was made on behalf of RRCHS that since they are bona fide purchasers of the subject land from the members of the Chavan family, they would be entitled to allotment of an alternate piece of land, as has been done by them in the present proceedings. We however find that the facts in the present case and the facts in IA numbers 1 are totally different. In the said case, the state had illegally taken possession of the land belonging to the predecessors and title of the applicants therein. Not only that, but the said land was given to the Armament Research Development Establishment Institute, which was a unit of Defense Department of the Union of India. There was no acquisition proceedings. The applicants therein fought right from the trial court to this court and succeeded in getting a decree for possession of the land. When they put the decree in execution, the ARDI opposed the same, contending therein that an armament defense establishment was constructed thereon. Faced with this situation, realizing its mistake, the state government allotted another piece of land in lieu of the land which was already given in possession of the DEI. However, the record subsequently revealed that the land which was allotted to the applicants therein was notified as a forest land. Therefore, the Additional Chief Secretary Revenue and Forest Department Mantralaya rendered an undertaking before this court, agreeing to allot an alternate piece of land in favor of the applicants therein. Accepting the said undertaking, this court passed an order on 9th September 2024, the present proceeding. That is not the case here. The RRCHS, knowing very well that the land was a forest land, had entered into transactions with the members of the Chauhan family much prior to the land even being allotted in their favor. The transactions between the RRCHS and the members of the Chauhan family were totally illegal and contrary to the conditions on which the land was allotted to the Chauhan family. It is thus clear that the case of the RRCHS is in no way bears any resemblance to the case in IA number 4. If a direction as sought by the applicant RRCHS is issued, it will amount to granting a premium to the RRCHS for the illegalities committed by them. In that view of the matter, we do not find any merit in the said submission. The last issue that we have framed is as to whether the doctrine of public trust would be applicable in the facts and circumstances of the present case. We have relied on a recent judgment of this court in the present proceeding, wherein this court had an occasion to consider the importance of doctrine of public interest in the environmental matters. As already discussed here in above, as per the orders of the Tahsildar Haveli, the land was allotted to the Chauhan family on ex-valley lease, and as per the undertaking of the Chauhan family, the possession of the land was to be returned on the expiry of 1 year there, and that there has been no further renewal. It further appears that thereafter the members of the Chauhan family were in deep slumber. From the records, it appears that one Mr. R.S. Chauhan, a retired police inspector residing in Pune, and others for the first time started agitating their rights on 4th of August 1988. It appears that thereafter, for the first time, the collector Pune on 19th of June 1991 recommended the permanent allotment of the subject land to the Chauhan family only insofar as 3 acres and 20 guntas are concerned. In spite of noticing all these facts, the Divisional Commissioner recommended that the entire subject land of 11 hectares, 89 hours be granted to the Chauhan family. Thereafter, the matter remained pending at the level of the state government. The then Minister for Revenue considered the proposal and came to a conclusion that the provisions of the 1980 FC Act were not applicable to the present case. However, it decided to seek the opinion of the Law and Judiciary Department of the Government of Maharashtra. The Deputy Secretary to Government Law and Judiciary Department on 27 July 1998, relying on the judgment of this court in the case of Banshiram Modi, opined that the permission of the Government of India is not necessary. While doing so, he totally ignored the specific judgment of this court in the case of Ambika Query Works and the directions of this court dated 12th of December 1993, the present proceeding. Almost within a week thereafter, that is on 4th of August 1998, the Government of Maharashtra issued an order allotting the land in favor of Chauhan family. The alarming speed with which the events took place from July to August 1998 speaks volumes. In the light of these glaring facts, there are no hesitation in holding that the then Minister for Revenue, Government of Maharashtra, and the then Divisional Commissioner Pune have acted totally in breach of public trust to illegally cause gain to a private individual at the cost of sacrificing precious forest land. While hearing this matter, another glaring issue has come to the notice of this court. It has been noticed that a vast stretch of the land, which is notified as forest land, is still in possession of the Revenue Department. Such a situation creates many complexities, as is evident in the present matter. The Revenue Department, despite resistance from the Forest Department, allotted the land to private individual institutions for non-forestry purposes. This in turn reduced the vital green cover. We therefore find that it is necessary that a direction needs to be issued to all the state governments and the union territories to hand over the possession of the lands which are recorded as forest land and which are in possession of the Revenue Department to the Forest Department. The report of the CEC would also reveal that there is material to show that many of the forest lands have been allotted to private individuals, institutions for non-forestry purposes. Any such allotment after 12th of December 1996, that is the date on which the directions were given by this court in the present proceeding, would not be sustainable in law. It would therefore be imperative that wherever it is possible to take back the possession of such land, the state union territory should do so and hand over the possession to the Forest Department for forestry purposes. However, if on account of such land already being converted for non-forest activities, it is found that taking back the possession of the lands would not be in the larger public interest, then the state union territories should recover the cost of the land from such individuals, institutions, and use the said amount for the purpose of afforestation, restoration, and conservation. We therefore dispose of the interlocutory application and the writ petition the following terms. We hold that the allotment of 11.89 hectares of reserved forest land in survey number 21, old survey number 28, Kondwa, Budruk, in district Pune for agriculture purpose on 20th August 1919 and subsequent permission given for its sale in favor of RRCH on 30th October 1999 were totally illegal. We further hold that environmental clearance granted by the MOF on 3rd of July 2007 to RRGS is illegal and is accordingly quashed and set aside. Since the state of Maharashtra has recalled the communication dated 4th of August 1998, approving the allotment of the subject land to the Chavan family, we uphold the same. We direct that the possession of the subject land, which is reserved as a forest land, but is in possession of the Revenue Department, to be immediately handed over to the Forest Department within a period of 3 months from today. We further direct the chief secretaries of all the states and the administrators of all the union territories to constitute special investigation teams for the purpose of examining as to whether any of the forest land in the possession of the Revenue Department has been allotted to any private individual institution for any purpose other than forestry purpose. The state governments and the union territories are also directed to take steps, take back the possession of the land from the persons, institutions in possession of such lands and hand over the same to the Forest Department. In case it is found that taking back the possession of the land would not be in the larger public interest, the state government union territories should recover the cost of the land from the persons, institutions in occupation thereof and use the said amount for the purpose of development of forestry. And we further direct the chief secretary of all the states and the administrators of all the union territories to constitute special teams to ensure that all such transfers take place within a period of 1 year from today. Clearly state that hereinafter such land should be used only for the purpose of afforestation. Before we record our deep appreciation for Sri Parmeshwar, Learned Senior Counsel, ably assisted by Mr. M.V. Mukunda, Ms. Kanti, Ms. Raji Gujarat, and Mr. Srinivas Pati, Learned Counsel, assisting him for rendering valuable assistance to this court as amicus curiae. We also place on record our appreciation for the assistance rendered by Dr. Singvi Devra and Mr. Kulkarni appearing for the state of Maharashtra.
Joshi. Joshi.
Sorry. करने कुछ
Please.
Also in this matter, the computer
It's not to be deleted.
not to be deleted.
Yes, you said not to be deleted.
First IS, three separate respective to list one next connected IS.
Not to be deleted.
Connected IS coming up on Tuesday. It's not an 803 not disputing medical examination not for first year students and
It is on 15th of July.
so not examination not saying August month, it's already been declared notes. Examination is going to take place in August. It's not have 4 vacation. Right.
Full vacation is different only 1 week we have.
Not
Please speak in the mic.
so examination schedule has been declared for first year notes examination notes.
It is declared or yet to be declared?
Declared notes.
So when is that?
25th of August notes examination scheduled.
August, we are having it before that,
Not for that, not to be deleted.
not to be deleted,
I'm so great. So great.
not to be deleted.
My lord, this is a matter concerning non-grant of grace marks to a disabled petitioner.
Non-grant of?
Non-grant of grace marks. Notice has been issued. It was directed to be listed after the Diwali vacations last year.
Listed on 5th of August.
20th of May is the computer generated date, my lord.
No, 5th.
Not shown, but now it is deleted. Now there is.
804.
Mentioning.
Okay, not to be deleted.
Not to be deleted for 20th May, my lords.
My lord, it's not anymore showing for 20th of May. It was earlier shown for 20th of May. I have said so in my mentioning letter. my lord.
Last week.
Great.
Yes, that's introduce 6. I would seek the.
Listed on 15th of July.
It was showing for 13th, but it was not listed.
15th of July, not to be
Maybe
deleted.
next week maybe. Some date maybe.
Yes, 15th of July, it is already there.
Please, Your Lordships. Your Lordships, in this matter, Your Lordships, the High Court has taken suo motu cognizance and has asked for,
What sort of statement you are making?
Your Lordships, an apology
Not
has,
the responsible minister of the,
that may be so, Your Lordships, a state.
the country
we
is
have-
undergoing
we have-
such a,
We have
such a
expressed,
situation and
we have expressed our remorse. In fact, I have the recording of his remorse, which he has publicly stated, Your Lordships. It was a statement which was misunderstood as well. That I can justify to Your Lordships, that it was a.
So person in holding such a constitutional office is expected to.
He has expressed,
Exercise a
expressed-
degree of restraint.
Your Lordships, he never meant what has been made out by the media.
When those countries are undergoing
Your
such a
Lordships,
situation,
media
every
has-
sentence of word uttered by a responsible office, responsible minister has to be
Unfortunately,
with sense of responsibility.
Your Lordships, unfortunately, the media has overhyped what was said. He has expressed his apology,
anyway, I
he has
think
retracted.
Now the FIR is already registered.
Your Lordships, I'm praying for the FIR to be stayed at this point of time, because firstly, Your Lordships, I was never heard. Secondly, Your Lordships, suo motu cognizance without the procedure of 174 being followed, Your Lordships. In law, Your Lordships have always said that the High Court will not do this. High Court has exceeded its jurisdiction, in my humble submission, Your Lordships. I'm just praying that till I'm heard, Your Lordships, no action be taken against
No,
the,
but then why not 226?
Your Lordships, I have,
Why not 226?
Your
Merely because
Lordships-
somebody is a minister, should we entertain here?
Your Lordships, I have apologized. I have,
Go and,
I'm just saying one thing, Your Lordships.
go and apply before the High Court. please.
Your Lordships, I'm just saying one thing. If Your Lordships just sees the High
Sorry,
Court
sorry,
order,
it is under the
If you're-
directions of the High Court.
Your Lordship sees the High Court order,
We'll have it tomorrow.
very well. And in the meanwhile, Your Lordships, no further proceedings are
I think
going
it's
to
likely to happen in 24 hours.
Your Lordships,
You-
I'm
you know
I'm
who-
a minister.
You
that
know
is-
who you are.
Your Lordships, I'm a minister only for that reason. I'm saying no further action because today the matter is listed in the High Court, Your Lordships. So Lordships may kindly
You
indicate. to
inform the High Court that
registrar-
the matter is listed
Yes, Your
before
Lordships.
tomorrow.
The registrar may be informed in the High Court that the matter is listed tomorrow. Until that,
Will-
nothing should be done.
No, you can also inform that it is listed.
We'll also inform Your Lordships, but
Every day, by evening, by now it will
Yes,
be already
we will,
patched that
we will,
the circulation is granted for tomorrow.
and we hope that nothing further will happen till tomorrow, Your Lordships. That's all that I'm saying.
Already it must be there.
Therefore, Your Lordships, everybody may hold their hands as of now till Lordships hears us. That's all.
Tomorrow.
Very well. Great.
Lord, with the Lordship's leave, Lord, may I mention a petition on behalf of Vodafone. Lord, there are three players in the telecom sector. So, Lord, it has been subject of a judgment of this court, where, Lord, penalty and interest has been of about 30,000 crores. We were unable to pay. The government of India has now taken 49% equity, Lord, in our company. So they are like partners now. So we want, Lord, some further reliefs, Lord. The government is handicapped because of the judgment. We have filed a petition and requested the SG, Lord, to be here. The
I
government,
think the curative has already been rejected.
no, we have filed a fresh petition for certain other, Lord, situations which have transpired in the last 3-4 years. I am requesting it may come up on Monday, Lord. I have requested the SG because the government of India has now 50%.
Have it on Monday, my lord. I'll examine and take, I do not know, my lord, what my learned
Let's
friend
take
is.
it on Monday, Lord, something. will
Government
come out,
is,
Otherwise, the sector will collapse.
I'll take instructions, my lord, on
Monday,
Monday and
Monday.
I'll assist.
With the Lordship's permission, may I mention SLP, Your Lordship, the SLP, the matter has been settled. We are carrying a demand draft also to be handed over and the matter can be put to rest, Your Lordship.
It is listed today.
It's not listed today, it's listed on 22nd, but Your Lordship, the matter is listed before Punjab and Haryana High Court and the magistrate on 20th and 21st. So if the matter is
So
not
what is
concluded,
listed before us here?
Your Lordship,
What is listed before us?
Your Lordship, the SLP was listed and the SLP is now listed on 22nd for compliance. The matter has been settled. Your Lordship had passed the detailed order last time. If I may pass on the order, Your Lordship.
We will pass an order on 22nd, you take an
Your
adjournment.
Lordship, before that, the personal appearance of the client has been requested or directed by the court. So that may be a difficulty. That's why Your Lordship will just take a look at this. The matter is over. The other side lawyer is here. We've got the demand draft also as the settled amount.
You could have sought for exemption on that date itself. You could have sought for an exemption on that date itself when
Yes, Your Lordship, it should have ideally. Therefore, we're carrying the DD so that there's no pending amount in the matter.
till the matter is listed. Personal presence of the petitioner or direct, which
Petitioner.
petitioner is the company.
Petitioner is PP Gupta is the petitioner, who is the managing director of the company. Petitioner number 2 is the company, Techno Electric.
All this shows Techno Electrical and Engineering Company Limited as the
Techno
first.
Electric is the company, Your Lordship, and therefore there are two SLPs, if you see, 715 and 714. One is by the company and the second is by the managing director.
May I mention a fresh matter for listing next week, Your Lordship?
The personal appearance has been
Yes.
presented. Obliged.
Fresh matter for
Why,
listing.
why don't you stop the listing procedure?
This is urgent because this was filed last week.
No, but then first you, if in spite of the matter not being listed through the regular procedure, then we can understand, but you don't even make an attempt, then directly mention it.
It's urgent because state
So
government.
you come through that. If you don't get a circulation, we'll consider it.
My lord, I'm making a request, my lord. A judgment was uploaded yesterday at 1 o'clock for my client Soumya Chaurasia. My lord, the other matters are listed today, which Justice Suryakant, my lord, in court number 2. My lord, I'm just praying if it can be listed tomorrow or next week, my lord.
No, when are they listed before Justice Suryakant?
My lord, they're listed today in the list. The same scam, they listed today in court number 2 as item number 16, same FIR, my lord, same scam. And the judgment of my matter, my lord, was uploaded yesterday at 1 o'clock. I filed the SLP last night.
उसके साथ लगा देखिए सेम मगर है
My lord, it can be listed tomorrow. Today, it's not possible. My lord, tomorrow you will. Thank you.
Let's in item 1.
Well, it's,
The
just
CC is now filed
one
an
update.
CC is
Just
now
one
filed an
update,
addendum
Millards.
report, Millards. Your lordships kindly have the report. I'm
Millards,
sure the
can I
state
just
wants
give
to
an-
respond to that.
Can I
But
give an update? I have filed a counter. They have not filed anything. Obviously, I filed
you
today.
are appearing for whom?
I'm the Telangana state. Well, this is that university matter. The CEC which he's talking about came to us at 5 o'clock yesterday. Everything is state, nothing is happening on the site. We have completely in spirit and letter obeyed your lordship's order. My suggestion, subject to my lord's discretion, is that if they want to file a rejoinder to my very detailed counter, but I have to see the CEC report and examine more important. The Advocate General is here. They-
It's a sumo to, where is the question of rejoinder?
No, I'm saying in case somebody, that is one part. Whereas the CEC report on which is relying is the other part which came yesterday.
Amicus is not appearing for any party to file a rejoinder.
No, not Amicus, well, there are other parties. This is not, there are people who have filed IAs and complaints. They filed, I'm not talking about the Amicus.
Lord,
So I'm saying,
I was
well,
filed,
we
but
end up
I am
taking double time
for
of
the
the lordship's
student.
order access.
Well, Lord, I
On this CEC,
just
it's come at 5 o'clock yesterday.
I was filed one IA, my lord. I'm facing the criminal charge of more than 200 people, my lord, a student, my lord. And 3 FIR was registered, some of the inside the jail, my lord. Some of the examination is going on. We are the whistleblower, my lord, to save the forest and all that. So they are registered, the FIR, the student, my lord. The serious threat and examination is going on, my lord. I am inside, my lord. 58, some of the FIR 58 numbers, some of the not name. So anybody, they took the student and put on the jail, my lord. And 3 school already collapsed in that particular area, my lord.
3
School, running school, my lord.
collapse.
Yes, my lord. They bulldoze.
What will?
Yes, my lord. In my IA number
File
1.
a separate petition.
First time I'm hearing of this.
Oh, this is the situation, my lord. This is a completely lawlessness, my lord.
You can't enlarge the scope in an IA. We are only
But
concerned.
I'm the whistleblower, my
Oh,
lord.
sorry.
Student is a whistleblower and their examination is going on.
We are
Some
concerned
leniency-
here-
Some leniency, my lord, at least.
We are here concerned only with the protection of that forest.
My student is also future of this.
Don't enlarge the scope of.
Student is also in the future of nation, my lord, and they are facing the.
No, take separate proceeding. You are entitled to file proceedings for caution of the FIR if you are so aggrieved.
Liberty, then I will file a separate rate petition, my lord.
We are not inclined to entertain the IA. Because of it. With liberty as available in law.
Yes.
We received.
So you want when? When do you want it?
Well, it's whenever your lordship, I'm not, it's just we received
But,
5 o'clock yesterday. Everything is stopped.
Everything is stopped.
Yes, your lordship will take my word for it. We've got the AG here. AG is here. We made sure we've got the wildlife warden to do a lot of things the lordship mentioned last time. All that are placed properly before your lordships. Nothing is happening there, lordship will be certain about it. Not even they will say that.
I understand they have to file a reply to this because the Forest Survey of India has now said the Forest Survey of India has now given a report to the CC after using satellite imagery and ground truthing that out of the 104 acres that they cut within 2 nights, Millards, more than 60% of it is moderately dense and heavily dense forest. So very clear findings that if they want to file a reply, they will file a reply. Millards.
This is the first time in about 50 years they're saying so, so at least we must have a right to.
First time?
This forest declaration by the CC is this view of 40% all is first time.
In any case, even for felling trees, you are required to have permission of the.
That part is covered for you. That time we pointed out X number of trees, some 20 or 100 or some trees were done. We lordship gave your lordships a exemption, which may or may not apply, but we've stopped all that. No exemption because we claimed under the statute. I pointed out your lordship's self-certification that is objected to. All that your lordship will go into. I have no problem, but the real point is, as well, Chief Justice Gawai said, was that is nothing there on the.
And did you have an EC clearance?
No.
Did you have an EC clearance?
Well, it's EC clearance, the other argument less than 50 hectares, etc. Nothing.
No. It's I think 20,000.
What they did, Millards, they split it into 49. They asked three.
There's a
They
tree
took
the lordship
permissions for
recollect.
3 parcels.
In my
49.0,
counter, I have pointed out the
49.0.
self-certification procedure for trees below a certain height was pointed out your lordship
If
last
you
time.
want you to be saved from contempt, better take a decision to restore the forest.
No, it's already the World Wildlife, that wildlife warden under.
Otherwise, let your,
Very strong.
otherwise let your
Rest
chief
with-
secretary be ready to.
Well, we have planted and ongoing, when I give your lordship the full report with the photographs, your lordship will be pleased to know. Your lordship's order is being obeyed and implemented not in letter but in spirit. Huge forestation, planting, all that is going on. So I want to make it a consolidated presentation.
In that area,
Or the
not
first,
in that area.
not in that area, my lord.
Not in
Not
that.
single sapling has
Well,
been
we've
planted.
got very well, if your lordship will
I've only got the benefit.
In the
we've only
counter
got the benefit
affidavit-
of The CEC report.
Well, as in the counter affidavit, at a certain page, we have dealt with that.
Nothing.
42 onwards, what the wildlife warden says. I'll place it together, lordship need not have it piecemeal.
Okay, we will have it after vacation.
Yes, please give a date and we'll file it.
We are putting you on guard.
Here,
Try
lordship.
to defend, if you are try to defend such a thing,
No,
the
loud and
chief
clear.
secretary and all those officers involved will be in a deep
Last
trouble.
time itself, Manoj, we had made sure that nothing of the sort happens. Last time, this is coming up.
Then you should not have indulged into this thing. They are taking an advantage of the long weekend, do you do all these things?
Well, as we did, what we did was, we believe
Mr.
143 trees.
Dr. Singhi, have you seen those photographs? Have you seen those photographs?
No, we have some of them here.
No, a dozen bulldozers, can you just make an arrangement within a short span?
We have,
Prima facie appears that it was all pre-planned.
no.
The 3 days holidays coming
No.
and take advantage that the court should not be available.
After 1 year of winning 10 years of litigation, we won in the Supreme Court in 24. This institutional process of approval giving took 1 year, not that over the weekend. I'll satisfy my lords on the counter. 1 year.
The deforestation is only over the weekend.
The decision went to files. We decided to start construction. We believe this self.
And then you have,
That's
no, no.
ultimately will happen over.
No, if you are bona fide, then why did you not start it on Monday? Why only start it at the beginning of the long weekend?
This weekend was, I'll deal, I don't think this was highlighted. I'll deal with it. Lordship may, there's nothing.
Have it after vacation or how much time will you require?
After vacation, whatever, your lordship will give it in
No.
middle of July.
So you are saying that you want to respond to.
Yes, so we
CEC
will
report.
do it in 4 weeks. Your lordship may put it in middle of July or whatever lordship suits.
Just one submission, my lord, if there has to be a restoration of the forest, that has to be done. It has to be done during the monsoon period. In Hyderabad, my lord, the monsoon starts on 10th June, but the matter may have to wait till July. I understand that. But the state's response that they have filed, they have only tried to defend their action and they are saying that they want to go forward with that IT construction. They have not placed for your lordship's consideration any alternative proposal should this defense fail as to what they are going to do for restoration. No restoration plan placed before your lordships. I am requesting, let the state come with that proposal just in case their contention on merits goes. Then, my lord, the forest will have to be restored, but they have not said anything today. And if the matters are going to July, my lord, we would not have much time for that restoration plan to be implemented.
Already the wildlife warden at page 41 onward is
That's
described
only
what is happening.
protecting the wildlife.
Actually, protection of the wildlife, because we had seen those pictures of those deers and all.
Action is going on. My learned friend can't be saying today that we are doing something in IT when he's saying not a leaf is moving there. That's only prejudicial. Not a leaf is moving there on IT, Malas. What is the point of prejudicial lordship by saying
Counter,
that?
they have not said that they have dropped the plan.
Yes.
The counter,
we are not
they
supposed to
they are
say
very
that, supposed to
clearly
convince
said
your lordship
that they
first.
want to move ahead with the development.
That is after convincing your lordship.
If Dr. Singhvi wants his chief secretary and half a dozen officers to
See then.
to shift to a temporary prison to be considered alongside
Can
the
I
lake,
say one thing?
then it is your choice.
Malas, is it not unfair for the last sentence? I am here to persuade my lords that both ecology and IT can go together. I can't persuade your lordships. I must drop it today, here and now, before lordship hears me.
And
The correct thing for him to say is, am I doing something on the site?
Dr.
I'm
Singhvi,
doing nothing.
that is another issue.
Yes.
Whether the ecology and IT, because we have always been advocates of sustainable development. That is not the question here. The question is felling of thousands of trees, taking advantage of the long weekend.
Number one, not thousands. I will show the 147.
You have seen the photograph.
No, but I'll show that. But let him not say that I can't convince your lordships either way. He says,
Anyway,
drop the plan today. He says, drop the plan today. Here and now, where I'm arguing.
Don't bother him. It is for the state to make a choice.
Yes, yes.
Whether they want to restore the forest or they want their half a dozen officers
Oh,
to go
it
to
died
prison.
by lordship spirit of
When
my lordship.
July.
Some date middle of third.
My lord, I'm,
Students, please
All Malas.
don't mix up the issues.
Video of life.
Yeah, this is the difficulty in Supreme Court. Everybody wants to jump in. It's an issue not today, not directly, indirectly connected.
To fish in troubled waters. They also want to fish in some troubled waters.
May,
We already granted liberty, otherwise we'll withdraw that liberty. Nikal do. The IA is beyond the scope of the present proceedings. And then after we pass the order, what is this practice? Just because we are shouting at the state government, you want to take advantage of that?
That's the problem.
may I submit one thing?
Yes, you have been.
In 1.1, my lords, I filed a writ petition. My lords have annexed all the photographs in which the demolition deforestation took place. No counter has been filed, my lords. If your lordship may please us, they'll file a counter to this.
Same for everything.
Same
Yes, your lordship,
1.
record is a counter for everyone. Everything is there.
My lords.
Anyway, whatever response they have filed to the Sumoto,
Reply to all.
we'll treat it as a reply to all the.
I'm grateful, my lords, because I filed all the photographs.
Please be sure.
Yes, yes.
July, when are we taking a green bench on July?
20th or 21st?
28th.
28.
28th to 8th.
Date we have like.
Have it prior to that. We'll have it on a special day.
Yes.
We will have it on 23rd.
Yes,
23rd.
Yeah, 23rd. Yeah. Because on 28th, there will be other matters also.
yes.
Top of the board. members.
Don't have to.
Very well. 23rd of July, your lordship. July. Obliged.
I'm grateful.
Yes.
तो चला गया उसके बाद में दो चला गया
There's an item 2, Malaj, I'm praying that the matter may be referred to mediation, Malaj.
Who is appearing for the petition?
Malaj, nobody is appearing for the petition, Malaj, that's why I was not making that request.
Pass it over.
Please, Malaj.
Please, my lordship.
In spite of being duly sworn and allowed.
My lords, both the parties have amicably resolved the dispute.
Resolved.
Yeah.
The Senate considers the petition.
Seeking leave to withdraw.
Does it come in practice now?
Is
in practice? Subsequent to the orders filed. by the court. The matter has been amicably settled. Petition is therefore disposed of as having rendered infructuous.
I'm for the
In
petition.
spite of being duly sworn and appears allowed.
Please, my lords. My lords, I'm appearing for the petitioner wife.
In spite of being duly sworn and appears allowed.
I'm grateful, my lords.
My lords, I am appearing for the respondent, my lord. This is a petition where they are seeking.
Petitioner, my lord, this is my transfer petition for transfer from Gwalior to Telangana, Hyderabad.
This is
In
not a
this-
matrimonial case, my lord. It's a 138 case, my lord. They are seeking transfer of, my lord.
The issue is pending before this honorable court, and these all issues have been considered there. My lords, my lords, I'm furnishing the orders. Similar issue is
What ground you are seeking transfer? Where was the check presented?
My lord, Gwalior, check was presented Gwalior MP, my lord. It was bounced at Gwalior MP, my lords. The witnesses
My lord,
cite.
on their instructions of the payment being stopped. We stopped the payment. Thereafter, they have presented those checks. The checks were for as security purpose they were given.
No one.
They have to be presented only after the completion of work. But without completion of work, they
That's a matter of defense, madam.
informed us.
That is matter of defense.
Yes.
Where was the check presented by them?
At Gwalior, Madhya Pradesh.
They are asking.
My lords, at Gwalior, they presented those checks.
And where was it dishonored?
Gwalior.
It's not as if dishonored is some financial company merely taking advantage that they are having 100 offices throughout the country by filing petitions at.
My lords, the orders I have forwarded. My lords, at second page, the same issue is pending before this honorable court, where it says second para, no cause of action occurred within the jurisdiction of court at.
But here the court of cause of action arose within the courts jurisdiction of courts at Gwalior.
My bank is in Telangana, Hyderabad, and my lords, all my witnesses, bank, everything is in Hyderabad. Nothing is there.
My lord, sir,
May be permitted to appear online.
Liberty to appear through video.
my lord. Deeply obliged. Item 7, this was a cancellation of bail that was sought. A woman in her matrimonial house passed away within 4 months after the wedding. I think the state has filed its
Yes.
counter.
I appear for the state. Who is appearing for the respondent? Actually? They have filed their counter appeal.
Section 306 has been invoked. She was found hanging by her sari in her house. Husband was the last seen person.
We have filed charge sheet under 498A and 30. So what is the cause of death?
My lords, I'm appearing for R2.
Yes, madam. She died by hanging. 25th is the incident. No, no, so what is the medical report? The death is suicidal or homicide? Suicidal. Okay.
Obliged, Lord.
I please, my lord.
Chips.
I appear for the state, my lord. I am seeking some more time to file a counter, my lord.
Lordships, my counter has been filed, but it couldn't come on record.
So kindly come after vacation.
No,
If-
like,
Item 9, my lords, he's joined investigation. He's joined investigation, my lords, after my lords.
Yes, lord.
Yeah, pursuant to the interim orders passed by this court, it is joined. The petitioner has joined the investigation in that is also matter. So I intend to allow the application. The order is joined, so it made absolute.
Obligement. Lordship, I am appearing on behalf of the state in the matter, your lordship. Time be granted for filing the reply, your lordship.
Counter has not been filed, my lord. Excuse me, lordship.
But already put it. Petition at the request of the.
May please, Your Lordship. My lord, we have joined the investigation and charge sheet has been filed.
Who is appearing for, yes, Mr. Manoj?
Because I appear for the state.
Mother-in-law, mother-in-law.
But we found that there were instances of dowry demands and harassment. That's why she did.
Not a husband.
No, my lord, I agree. Just one thing, my lord, that 82 proceedings had been initiated.
Your Lordship,
They have not mentioned.
we have been enlarged on
Otherwise-
bail, Your Lordship.
The-
My lord, I am appearing for complainant, my lord. In fact, she had made a complaint 2 days prior to her death, my lord. That I have placed on record through
Yes, mother-in-law, father-in-law, it's not a husband.
My lord, the connected matter is the husband.
connected matter of the husband.
11.1 is the husband.
Husband, we are not.
My lord, may I submit? Lordship, may kindly have para 9 of the state counter. They are submitting that she has consumed poison in the police station, Motihari, and in the counter affidavit.
My lord, within
Yes.
within 3 months of death, marriage, she has died, my lord. She was in her
He
prime age.
had consumed the poison in the presence of.
And in- my-
That is true, my lord. She consumed poison in the.
The application is vehemently opposed by the learned counsel for the state as well as the learned counsel for the complainant. However, taking into consideration the facts and circumstances, we are intent to allow the application. Order is made absolute.
In both, what?
But my order dated 21st February 24, my lord, 1 year time was fixed for the purpose of seeing the progress.
Trial is yet to commence, Mr.
Yes, my lord.
Trial is yet to commence.
That's considering, my lord, that he was absconding, my lords, the lordship may put in to strict conditions, my lords.
Correct. The application is vehemently opposed by the Thackeray, the learned age. Correct. However, taken into consideration the fact that the petitioner has been incarcerated for a period of more than 3 years, and that trial is yet to commence, we are intent to allow the application. The application is allowed. So and so. The taking into consideration that the applicant was absconding, who was apprehended. The learned trial is both stringent conditions so as to secure his presence for the trial.
Lord,
Obliged.
Well, 12 ki 13.
13. May it please your lordships. Lordships, there has been no progress for past 2 months. Witness number 6, he has not been appearing in the trial. Now,
Machinery seized from your house, Mr.
yes, on the last occasion also, your lordships, I have shown your lordships the statement of the punch witness and the seizure witness. 3 of them have said that we have not gone to the place. Our signatures were taken in the police station. That is already on the record. Now there is the FSL officer who says that I also don't know whether these notes were fake or not. There is a cross in additional documents, I have filed that. He says, therefore, it was sent to the FSL, and FSL report is yet to come.
How many days you are inside?
Almost 2 years now, Your Lordships.
Well, it's an
Yes.
instruction that the FSL report has come, my lords. I don't have a copy with me right now.
Yes, madam.
My lords, but my lords may kindly see the materials which has been seized, my lord, from his house. The machines, the printer, my lords, the notes, my lord.
He said the FSL report,
600,000, my lord, 600 numbers of 2,000 rupees note, my lord.
the application is vehemently opposed by Mr. Deepak. Yeah. The learned counsel for the state. Taken into consideration the period of transition is intent to allow it.
Highly obliged, Your Lordship.
Obliged, my lords.
Application of bail. The petitioner has been in jail.
Yes, who is appearing for the state?
Aditya Pandey.
Yes, he is here. Yes, Mr. Pandey, have you filed your reply?
This is coming for the first time, the bail application. The other accused has been
Has been
granted.
already granted bail.
Yes.
Whether the role is similar.
Role is similar. He stabbed with the stone and there was an injury on chest also. Cause of death is head injury.
The application is vehemently opposed by.
As per the,
Mayor, madam, please permit it.
as per the personal, the injury was superficial in nature. And this.
Okay, it's all right, we've got that.
Whereas
We have heard, we've got that. We've got that.
The application is vehemently opposed by the Aditya Pandey, the learned counsel for the state. However, taken into consideration that the co-accused has already been granted protection by this court, we are inclined to allow the.
But yeah. Will be appearing for the. Put it away.
Yes.
Plus, this refers to the NEET PG answer sheet issue, transparency issue.
Will I appear in the lead?
Ajay was saying that the infrastructures for this year.
Lord, so many of these students, Lord, will appear next year, Lord, as I had indicated on the last. There are issues, Lord, which are not restricted to this year, Lord. There are petitions pending from 21, 22. There's a reason why your Lordship didn't dispose. All these are tagged with my petition being treated as lead. I had promised 15 minutes, Lord, I'll wrap in 15 minutes. I understand that what matters immediately after me, but.
Because we'll take some time because we'll have to show judgments by this honorable court on the same issue.
Yes, so that's okay, my lord. But exams are now coming in June, my lord. There's a time limit, my lord.
Because these petitions pertain to the examination for which the counseling is over, the admission is over, the session has also started. And for the next year, we are already before your lordships, with the matter is coming on 20th of this month.
We'll have it along with that.
My lords, the matter. The system has changed since then.
So therefore, if.
My lords, if I may.
If they are satisfied with the change.
No, we have seen that. That is not.
Have you seen the change system?
Because there are
nothing to do with our grievances.
Because there are two issues here. One was the normalization of marks, which is the same as the matter which is coming up on 20th, where we have changed the system. And the other issue is regarding the revaluation and the answer key, which is Milos peculiar to this matter.
So there are three other issues other than evaluation. Only normalization is changed. I have no grievance with normalization. But I need 15 minutes. I understand if it's to go on today, I can start. Otherwise,
But she's saying that the other matter is coming on 20, so we'll have it along with that.
That's only on normalization. I have no grievance with normalization.
So very well, Milos, those prayers then, Milos.
Yes, you can reject both. No difficulty.
My lords, if I may, I'm appearing in writ petition number 385 of 2024. My lords, ours is a PIL. So our issues that we've been raising, that students have been raising, appearing for different year and different batches. Well, that can be infructuous. Our petition is at least as maintainable. That's question number one. Secondly, my lord, the matter that is coming up on the 20th is raising a separate issue. They've not tagged it with these batch of petitions. That's regarding single shift and double shift. My lord, also since 2021, students appearing for NEET PG have been filing a petition every year. It is yet to be heard by my lords. And the next examination is now going to be on June 15. So it is imperative, my lords, that my lords hear us at least on the preliminary points.
So we'll hear you on 20th.
But my lords, the other matter which is coming up on 20th is not tagged with our matters.
So may not be tagged, but then if we find that some issues are overlapping,
But my lords, 15th of June is the next date of examination.
20th of May is after 15th of June.
Yes,
prior
well,
to-
my lords, then my lords,
My lords, it's a super specialized exam of the post-graduation. My lords, all over the world, the questions at that level of the appropriate difficulty are very limited. So, my lords, the answer keys, I will explain when I argue, my lords. It is, my lords, if 2,40,000 students take exams,
Yes. Well, give us 15 minutes on 20th, no difficulty. We don't want to spend, yes.
No, to that also there is an objection.
No, there is not from me, Lord. We don't want to spend 15 minutes asking for a date. Lord.
That's right. In fact, there
Well,
are
the
some
only thing
issues
is
which are
that-
common in both matters.
No, there is
Well,
not.
We'll have to take them.
so
That's why the second aspect is concerned. It's only moderation of the mark. That aspect probably will be.
I'll happily accept.
No, but as far as this is
Lord, then he-
my lords, covered by the two judgments of this honorable court.
That's
The laws would record, my lords, that they have no grievance as regards the normalization of marks.
preliminary objections.
By 20th, we will not forget.
Please, Your Lordship.
Memory may not be that good, but
Please.
not that bad.
Please, as your lordships, please. Grateful, ma'am. I'll you
Your Lordship, in item 14, Mr. Adsure has been appointed as a special counsel for State of Maharashtra.
Who?
Mr. Adsure. He's been appointed as special counsel, Your Lordship. There's a wedding in his family. I'm requesting next week it may be taken, if possible. I'm grateful.
Wait, please. Kushro, we have filed our detailed reply on 3 issues which were, my lord, identified.
May I please, your lordship, may I? Would my lord be kind enough to take up the act notes?
We are hearing today on interim relief or on the main matter?
Well, as far as the interim relief is concerned,
The
my lord,
learned,
he has given, so we don't want to argue the main matter, my lord. It can't be argued, but we are willing, my lord, whenever your lordships wish to hear it, we'll argue.
My
the
lord,
matter.
when I join my learned friend, my lord, whenever your lordships considers, today or any date, I don't think your lordships could have got time, my lord, to read yesterday.
At least I could.
I understand.
That's
I
why I myself
understand and
said, have it any day when your lordships can.
Lord,
hear the
kindly have
matter.
it next week, subject to your lordship.
Whenever,
But for interim order also, it may not take long, but it might take a little while. That's all.
No, it'll take some time. I mean, honestly, it'll take some time.
How much is your estimate on your side?
Well, it'll take 2 hours this side.
Almost a day because we.
Yeah.
2 hours.
It will, well, honestly, it will take time. I don't want to.
All of us.
Yes, all of
But it's a stay of statutory provisions, but I am not arguing right now. Lord, that would be, my lord, the major concern. But, my lord, I can't, my lord, say what time they will take, my lord, but some reasonable time, my lord, your lordships may devote next week, my lord. Otherwise, I understand today, my lord, the difficulty is a practical difficulty. I can't.
Lordships, insofar as item 16 is concerned, we are slightly different. Excuse me. Yes. In the sense that.
In
we've
fact, what
challenged
I've
the
done is, well, I've
provisions
prepared a note.
Which seem to have been.
If I can circulate to your lordships, well, it'll take less time. I'll give it to the other side also. What are the provisions which are per se unconstitutional according to us? So, well, they can also provide so that it's easier for us.
At least.
Have you
Huh?
furnished a copy to the learned SG?
No, regarding what? I'm sorry.
That note?
It will be filed. We can file this note. Let them file.
I think it's better you circulate that so that.
Yes.
You can also, if possibly can also punish us with a short note.
No, certainly, my lord, on my affidavit is, my lord, detailed, but we can file a shorter note
right.
because 3 issues are identified by the court, my lord, on which the interim order is to be considered.
Yes.
Not your.
Five lead matters. But five lead matters normally, the lead matter is only one.
Well, this,
Will not we'll consolidate a note. I think that might be better.
That would be better if we have,
I think we'll get together and consolidate.
no issue at all. We'll do that.
In fact, we have already shared our points with Mr. Sibal to try and.
I've already been incorporated.
May I suggest, subject to agreement by the other side, then there can be 5, my lord, now that that's a judicial order, my lord, we can do nothing.
rather than having any matter as a lead matter, let us have the issues which are required.
Exactly, my lord, let there be written note, my lord, consolidated.
Are required to be gone into for consideration of interim relief.
Perfect.
Lord,
That's
there
what
can,
we'll do.
Lord, there can be one written note on their side and one written note on our side. We will sit together and prepare a note. They can sit together and
Prepare it and we'll file it.
When can it, by when we can?
My lord, by
Monday, we'll.
By Sunday, my lord. No, it's ready.
By Sunday.
Mr. Sibal's note is ready.
Yes, by Sunday.
Just give it to me. We will respond to that, my lord, by
To
Sunday.
consolidate our arguments this side, my lords, by Sunday. So by Monday, we are ready.
Circulate it to all of us.
We'll circulate to everybody.
No, I had created a whole.
Circulate it to us also.
Yes, of course. We'll be in difficulty if we don't, my lord.
That's also into confidence.
Continue. Perhaps if the lordships could consider it.
Once we decide to.
As amended in 2025. So there is a third dimension. Lordship may give us half an hour so that we can also make our submission. We are also agreed. We are also agreed.
Never end.
We are also agreed by the present buff amendment at certain.
Whether in the last order that is mentioned.
Mentioned in the last order.
No, it's.
It is mentioned in the last order. That 2 writ petitions.
My lord, if it is shown, it is shown, my lord. Why are we arguing if there is already a judicial order?
Those 2 writ petitions.
Item 16 and 17.
Item 16 and 17, my lord.
So what is your grievance?
My lord, my grievance is that so far as the certain provisions of Waqf Act, so far as taxation is concerned, section 8, it is still there. Waqf tribunal, which is completely unconstitutional, it is still there. So there are various other sections which are completely draconian, which still exist in the statute.
They are existing since when?
1995 and 2025 also.
If they are existing since 1995 and if you are not challenging.
Well, we challenged it. We challenged it.
When?
We challenged it.
Challenge them when?
Challenge.
Let us not deviate from the order passed. Mr. Jain, please. Let us not deviate from the order already passed.
Challenged earlier.
There's no interim relief required.
Asked us to go to the High Court. We filed around 140 petitions which are pending in different high courts, and now we have filed the present writ petition, which is a fresh matter, challenging various provisions, my lord. It was challenged earlier.
Challenging provisions of 95 Act or 25 amendment?
1995 Act as well as certain provisions.
How can we permit you to raise a challenge to the provisions of 95 Act in 2025?
Interim relief. I appreciate. May I just explain, sir? Just.
At least no urgency for interim
There
relief.
is urgency for
my lords.
So far, sir,
After 30 years.
Lordship, may kindly appreciate. There are interim. May I just? I am also seeking interim relief, sir. It is there in my petition.
Are you seeking interim relief of the provisions of 95 Act or 2025?
95 Act, Section 3R.
That's the common issue which we are.
And there is certain deviation, Lordship.
But you argue when your turn comes, the deviation can be argued. It is taken care of in the earlier order.
Saying I must be given half an hour to, my lords, make my points.
We will sit on that date.
Section 3R, my lord, Shamlat Da, village land. That has not been repealed.
Shamlat De, I think is pre-independence act insofar as my learned brother would know it, but.
It's in Punjab or.
That's right.
I have dealt with one of the litigations from state of Haryana with regard to that.
Give us some time.
That is a pre-independence act.
Lordship, that's what Lordship may kindly.
It was.
Don't mix the issues and this.
I'm not mixing the issue. Lordship may kindly appreciate.
How can that be interim relief, my lords?
We will not consider any request for stay of any of the provisions under the 95 Act.
Yeah.
We are making it clear. Just because somebody is trying to make a challenge to the amendment of 2025 and somebody just wants to jump in and challenge 1995, that will not be permitted.
I think I am not able to communicate what has actually.
Well, let it be on, my lord, whichever date your lordship considers proper, my lord, Tuesday or
Court asked
Wednesday.
us to go to High Court.
Mr. Jain, please.
They've never had a stay since 1995.
Can I say my lord, one line, he wants to say that we have been waiting for that stay since long, but this court directed us that you go to the High Court and never considered our prayer for 95. I am saying what he is saying.
95 is considered in 2025.
Yes.
That's what, my lord, he has yes, my lord, there is some difference, but he is to be heard, my lord. There is no point arguing that today. That's all I am saying.
Tuesday,
So the intervention applications may be allowed, sir.
Tuesday, fine.
consider them.
Interim assurance.
Intervention applications are, Mr. Jain is a nodal AR for that, so you have to approach him.
Lord, there are three, I'm one of the nodal councillors.
Mr. Ejaz and Mr. Kanu
For
Agarwal.
interveners, it is Mr. Jain.
No, no.
my lord.
Yes, that-
They are
that-
writ petitions, all writ petitions.
There are three nodal councils. There are three nodal councils for the private interveners.
Yes, Mr. Kanu Agrawal, Mr. Azaz and Mr.
Mr. Jain, that third dimension, but interventions, my lord, they
Those-
can give their suggestions, my lord. That's all, my
The
lord.
earlier writ petitions were converted into intervention
Interventions.
applications, barring 5.
Yes, Mr. Vishnu Shankar Jain is a
That's right.
Yes.
for applicant. So you just ask
Yes.
for a word to contact him.
Lord, can it be on Tuesday?
Yes, Tuesday.
Tuesday, my lord, and the assurance continues because it's only till date.
Yeah, of course, of course.
Learned SD has made a statement.
Yes, yes, my lord. It must, it will continue.
The court order says only till, that's why, otherwise I would just.
No, that's.
To continue.
He is before the court, you are also before the court.
It possibly even doesn't say till today, it has expired, but it is continuing. My lord, that, I can't remain on that technical.
reflected.
Anyway, my lord, it continues. Let's not go into that.
Last order, sir.
Mr.
They are not an issue, not an issue.
Till the next.
The direct policy is before the court.
Yeah, that's right.
If somebody, some officer tries to play with technicalities, we are here.
No, my lord, before that, I am there. Don't worry, my lord.
My lord, may I just request, one small thing, sir. My lord, five petitions were identified as lead petitions. The rest have all become intervention applications. My lord, I'm all requesting is that 5 petitions may not be limited to 5 senior counsel.
No.
No, but that is decided and everyone has.
My lord, it's not been decided.
Otherwise, then it will not be possible for.
My lord, I'm just,
Here, this side of.
One of the 5, my lord, we can't object to that.
my lord, I'm saying this that in previous practice of this court has been to give a certain amount of time.
Thanks.
And then
Mr. Sibal has said that he will take 2 hours, so we request him that he should have a meeting with all of you and you
Yes.
decide as to how.
I think we have to subordinate our personal thing for a larger issue. Let one or two councils argue the matter.
That's what we say, that it is very difficult to
I mean, there's a,
control the, I'm sorry,
No, I'm
I also
saying-
belong to.
I'm saying we have to suppress our own personal urges.
After 24th November, I will also be that side. But our experience of all the judges who come from Upastil court has been that the bars there are much more disciplined.
Lord, if we could combine 5 or 10.
Really difficult to.
I agree.
But I think when, from Madhya Bharat in particular, even the high courts, the decorum is something which is unbelievable because.
You also have the experience.
our own-
The learned solicitor has an experience.
Coming from Gujarat,
Bombay
follow
bench and
my lord, Bombay
Nagpur
practice and it's completely different.
Bombay bench and Nagpur bench is like, one is like a circus and one is like a bench with great decorum.
But I must say that.
We always see that.
This has changed now. It never used to be like this.
Here it is, we are taking so much time.
Yes, I know.
Only to fix a date.
On a lighter note, can I suggest, my lord, to remove this difficulty? Please stop live streaming of this matter.
That's what I said.
I've advocated that all for a long
What
time.
should we fix the time? Why should we fix? What should we fix? Each
We are giving 2 hours, this side 2 hours to that side.
Correct.
And now, Tuesday, then we'll keep only this matter.
That's right.
But then it should not happen that for A reason or B reason, it doesn't go ahead and then we are left with no work.
No.
No.
No question, no
Lord,
question.
Mr. Sibal may share his note with us today.
Yes,
And we will file it by, my lord, Sunday, my lord.
Yes, yes, Sunday morning.
Well, since we live at a distance of 16-kilometer distance, I live in 16-kilometer distance.
From here? No, but why? You will be in Luton's.
But that is, I could not.
No, but you must be in the Luton's.
Yes.
The Luton's is.
I can attest to the proof that he's a very good Lutyens. Very. No, but you are living in Lutyens. You are living in Lutyens.
But Lok Sabha also is in Luton's zone.
Yes.
India and Mr. Sipal, that's my distance. I have to go back. Today I will do, again I will go back.
But we are all accountable, my lord. We are all accountable in some way or the other.
The Constitution. The privilege,
I was not arguing. Can you reconsider my?
There's already a member of the Joint Parliamentary Committee in the 5 also, ma'am.
Anyway, let's leave.
No, you have already
Let's get on
contributed.
with
Now let others.
Coming, please, stay, madam.
Mr. Banerjee, your contribution would be either used by this side or that side. So
Correct.
it will be there.
States also.
Yeah, he's right. He seems to be right. The rest of the states are not having any problem.
No, that's not right. That's not right, my lords.
I will try and echo his sentiments, but he should not be worried. I'll try and echo that.
Grateful, man.
Obliged. Lord, they may give it today so that we can give them on Sunday. They get enough time.
Need a
Mr.
little
Sibal, you can just hand it over to.
time to cumulatively.
No, it is ready. Mr. Sibal has made it ready. You must trust Mr. Sibal's notes.
The note
I have to
That note we can hand it over to the learned solicitor.
Yes, we will. We'll circulate, Madam.
Okay, you make the note final by tomorrow evening. Make the note final by tomorrow evening and give it to the learned SG and let the learned SG give it by Sunday evening. Or Monday evening.
Saturday, man.
Saturday we'll be able to give, not tomorrow. Madam.
Okay, Saturday, but then you will have only one day or
The Saturday,
Then
Sunday,
Monday morning, my lord, we can, Monday evening.
Monday evening you can give.
Monday evening.
See, that's fine.
Very well, that's fine.
We are not putting it on record, so but it is understood that by Saturday evening your note will go to Mr.
Definitely.
Yes, ma'am.
And both the notes will come to us by Monday evening.
Yeah, definitely.
Or would it be Monday afternoon?
We will be filing by Monday afternoon so that it.
We'll try and
reaches
get it
your
earlier
lordship.
also.
Otherwise, it doesn't reach.
We can give it in a physical copy to the court.
To the court
Yes,
master,
yes,
we
yes.
schedule.
We'll do that.
That will be better because here the,
Like,
if it is filed here, then that file might.
yes.
9 o'clock, 10 o'clock. So
That's right, that's right.
So traveling from here to here takes one of the entire route rather than.
We'll do both notes, we'll upload it and give the copy.
Yes.
give the physical copy.
Obliged. We'll be obliged.
Grateful.
Obliged.
Grateful.
Ask the order to process things. There are contempts pending. How do? There have been contempts have been filed. Not a concern.
Lord, I know. No, 23, no, maybe kept on Friday. It's an illegal demolition matter. We'll file our reply.
No, we have 21, I think now.
No, 23 was tagged with this matter, but it's a slightly different matter.
That Uttarakhand matter.
Yes. We'll file our reply below.
So next Friday.
Yes, 23 maybe next Friday.
You will inform Mr. Sibal, otherwise you will.
I will inform.
It was mentioned by behind my back.
No, I'll inform. Friday. Man. Yes.
Yeah, because
Thursday. Man. I have not,
Next Friday would be ceremonial bench. also.
yes, yes, but Thursday. Thursday. My lord, 21 is that, my lord, the open jail.
prisons, Lord, open prisons.
Open prisons. And your lordships were pleased to direct the registrar of this court to go and
Go and inspect it and
inspect and make a, my lord, he has made recommendations. We have accepted all recommendations.
But I would like to say that I have something to argue in that matter. I placed on record the structure and the reason, not the rationale behind this open prison. It is, and the reason why, while they have land elsewhere, not within the vicinity, the hospital can be relocated, but to constrict this place.
But he is a man in Assam doing some, my lord, filing a petition for Rajasthan.
Not a bad idea. It's national.
It is a bad idea. I'm
Sorry.
doubting your credential.
India is one.
Sorry, not this
I'm
can't be an
doubting
issue.
credentials
Why
in
should
a
we?
Why should we come in the way of the hospital?
I'm not. I'll just tell your lordship why. And may I just point this out? May I,
Report कहाँ पे है?
Lord, may I just point this out? So far as kindly just consider this, Lord. Lord, the prison existed there. May I just point out there is a portion of the land. Kindly just see that.
Registrar.
There's a registrar's report, Milords. So far as the state of Rajasthan is concerned, they have assured your lordships that they will not reduce the area of the prison. Because
He is the
yes,
and Learned Friend is the MI.
our concern, our primary concern was that the area allotted for the prison should not be reduced. That the state government is assured, Milords. The registrar also has given a number of constructive suggestions, which they have also agreed to. I think the primary problem they have is the fact that the existing shanties, those existing residential quarters for the inmates in the existing open prison, Milords, are not in good condition. Those photographs are there for your lordships. They want to reconstruct that into a multi-floor building, Milords, which they have some problem. But I don't think that should stand in the way of the hospital coming up. I don't think that should stand in the way of the hospital coming.
Not if we are demolishing, my lord, some old shanties and creating a better structure, my lord, how would ma'am putting a question?
You have a copy of the report.
Public
Lord,
interest.
let's have a look at the report, Lord. Lord, my lord may have a look at the report and then I'll make my submissions on it. Why? It's not that it's not possible.
Lord, Lord, I would make only one request. Lord, having my lord, a report of the registrar before your lordships and state government showing, my lord, unequivocal assurance that we will accept all the recommendations.
Let him have the pleasure of
Now, my lord, now at least examine his credentials. That why is he now stretching it?
But I think, Lord, may I just say this, Lord?
No,
this is now, I'm
this is
sorry.
going to the root of the matter, the credentials of the petitioner.
Mr. Mehta, can I also address?
No, certainly, but credentials of the petitioner in a PIL is a question.
It's the only question that is raised consistently. I'm sorry to say this, but let me make a case. I may be out, I may be in, Lord, but let me make a legal plea before your lordships. Please see the report, madam.
Oh, no, Yajwendra Singh का ना registrar उनका report है.
This will be 21st December 2024.
Lord, may I otherwise make a request? Lord, keep it at the end of the board. This matter will take a little time. Because I propose to ask you, if your lordship may keep it at the end today, Lord. It will take a little time.
The report निकाल के रखने ना वो. Yajwendra Singh का ना.
We'll address today and conclude the matter. No difficulty, but it will.
Mr. Ladekar.
I think Yajwendra Singh.
Mr. Ladekar.
Lord, can your lordships pardon my absence only for 2 minutes?
Then we'll have it at the end of the board. Or we'll have it at 2 o'clock.
It may be better for both of us. Let's finish everything else.
In the meantime, ask someone to.
I'll just get printouts, Milords. I'll just get printouts. I have a soft copy. I'll get.
Or, my lord, tomorrow, my lord. This is a short issue. Please go through the report of the registrar.
Why don't you want to trouble yourself on a Friday?
I bow. My lord, at the end of the board or at whatever.
Just get 2 copies.
At the end of the board.
Get 2 copies. Mr. Ladekar's report. Oh, envelope में file नहीं है. Envelope में होगा. File में नहीं है.
Lord, we'll carry copies of the.
Well, I'll carry copies of the.
Meanwhile, there's no difficulty. There's no
We
difficulty.
will have at a post plan.
Open. That's why I'm saying.
We'll have a post recess.
Post recess.
So there is a special bench, my lord, constituted by lordships at 2. It's a review.
After that, if possible, sir.
Oral hearing.
Some IBC issue, my lord. It was some insolvency.
Whether an oral hearing has been given in that.
It is, my lord, permitted. Oral hearing is an order pass.
After that.
And
which is a special bench?
It is a bench presided by my Lord Justice Sundaresh. my Lord Justice Dhulia and Justice Bhatti.
Bhatti.
And at 3 o'clock, my Lord, there is a special bench for presided by Justice Suryakant, Justice Dipankar Datta, and Justice Singh.
Let us see, do you have a copy of the report?
So I have a soft copy.
No, my colleague is here, my Lord. I'll be here in 5 minutes. I'm called some, my Lord, in court.
अरे इसमें envelope है ना? Envelope.
Ma'am, there should be a separate envelope which will.
No, that's not touch screen. Sorry. That must. Oh, yes.
मिल गई?
Here.
That will be the report. दिखाइए. We'll give this up. Just show it.
Oh yeah, that's the one.
We'll take it. We'll check it. ये वाला ये check. Then we send it. Okay. Still not it. Well, otherwise keep it back. We'll get printout for your lordship. Keep it after 10 minutes. We'll get printouts. 12:30, Lord.
What, 5-10 minutes?
5 times we'll get printout. It'll take 10 minutes to get printout. I'll get them immediately. Get printout. 10 minutes.
May it please your lordship. I appear for the petitioner.
Yes.
Very limited issue here.
It's 25.
27, your lordship. 27.
They are all connected otherwise.
They are all connected against common judgment, but 27, your lordships have issued notice, others are fresh matters. Lordship, I am only seeking parity with the highest exemplar. The
Who's for the?
MIDC is the contesting party.
MIDC. But my lords, in 27, since we notice has been issued and our counter is on record, but my lords, the other matters we don't have a copy because.
But he's saying
the common
is connected.
Common judgment. The only issue is whether highest exemplar cell deed was considered or not. My case is it was not considered. MIDC has filed a reply. They said it was an oversight by High Court. High Court also did not consider the exemplar.
Then what is it? What is there in the matter?
My lords, may I have the benefit of the other petition? We just need the copy. If they're similar, then at least we just need the copy. If it may be served.
Well, last time also they made the same prayer.
But the other matters were not there.
Other matters, I mean, it can be kept later on, but the lead matter where notice is issued, the counter.
Okay, how you file your reply in this matter?
In item 27 are.
They will take up 27.
27.
Proceed.
They have filed the counter. I'll show you one para from their counter where they accept that highest exemplar was not considered by High Court.
That has to be considered.
Lordships have the counter affidavit? MIDC's counter.
Then. Sorry.
Para 13 at page 5, your lordship. Third line, may I read it, your lordship?
Yes.
I submit that in para 49, the Honorable High Court has noticed that the learned reference code did not consider cell exemplar serial number 4, which is the highest exemplar. In para 50, the Honorable High Court held in that para 31 of the judgment of reference code shows that cell exemplar serial number 4 was also considered. This is nothing but an oversight and considering settled legal principles relating to interference in determination of compensation. In land acquisition cases, no case is made out by the petitioner for interfering with the impugned order. So They accept that serial number 4 was not considered by Honorable High Court. It was pointed out to Honorable High Court in para 17 and para 21 of the impugned judgment that reference court has failed to consider the highest exemplar.
Para 71?
Para 21, Your Lordship. Impugned judgment. Page 41.
Page 21.
Page 41, para 21. May I read it?
Yes, Mr. Deshmukh, yes.
Yeah, Mr. Deshmukh, learned counsel for the appellants, claimants further invited my attention to the impugned judgment and pointed out that the reference court has calculated the market price of acquired land by adopting average price method instead accepting highest bona fide exemplars, which is correct, which is incorrect in view of citations of Mehrawal Kevaji Trust and others versus State of Punjab. He submitted that when there are several exemplars with reference to similar lands, it is general rule that highest exemplar, if it is bona fide, needs to be accepted. Now, the finding of High Court in para 50, Your Lordship, may notice. Para 50. Page 62.
Yes.
Para 50, fifth line, Your Lordships. In paragraph number 31 of the impugned judgment, the reference court has also considered the sale instance at serial number 4. This is an erroneous finding. The reference court did not consider serial number 4. And this is what MIDC says is an oversight by Honorable High Court. I'll show you the reference court judgment where they have not considered serial number 4 at all.
My lords, I'm for MIDC in the matter.
Yes.
My lords, may look at para 49 of the High Court order. I'll read, my lords. Now the source which is available in exemplars which are on record to determine the market value of the acquired land. On going through the impugned judgments, it is noticed that the reference court has considered all 10 exemplars as shown in para 10 of the impugned judgment. However, not considered stale instance at serial number 4, which is from Jitnur pertaining to 96R land sold for the consideration of 72,900, which is found to be highest sale instance in the chart. As pointed out earlier, the market value of the acquired land is to be determined on the date of notification, which is published in the Government Gazette. So, my lords, the High Court has also said that the reference court is not considered. It's just that in my reply, I have said that.
Whether, as a matter of fact, the reference court has considered the exemplar at serial number 4.
4, yes.
No, Your Lordship, I'll show.
They are asking. Yes, madam. Has it been considered?
My lords, from the order of the High Court.
You pointed us from the order of the reference court that it is considered.
Yes, my lords. My lords, at para 50, it says that in para 31 of the impugned judgment, reference court has also considered the sale instance at serial number 4. At para 50 of the impugned judgment.
It is pointed from the order of the reference court that it has been considered.
Yes, my lords.
Exemplar on which you are list of the exemplars on which you are relying.
Yes, Lordship, it's reproduced in High Court judgment.
My lords, and in the reference court's order also it is.
Page 47. Page 47. Lordships have 10 list of sale deeds over there. Serial number 4 is the highest exemplar.
But it is 72,900.
Yes, sir.
The reference court has granted you 80,000.
No, that's per hectare. This is per acre, Your Lordship. Reference court has granted me 32,000 per acre.
That's 80,000 per hectare, my lords. And the LAR had, SLO had granted 10,000 per acre, which was enhanced by the reference court to.
So LAO
30,000
had granted 27,000
per hectare, my lord. Per hectare,
per hectare and the reference code granted 80,000
per hectare.
per hectare.
Yes, which now my learned friend is asking
No,
1,50,000.
In Chittoor is price per acre 72,900. Clearly shows the 72,900. Even in the other exemplars also show 61,500, 60,000,
Yes, ma'am.
41,000.
Yes.
Totally erroneous.
My lords, the reference court has considered page 106, the same sale instance. Somek, correct me if I'm wrong, please.
Well, it is at page 106 of the reference court's order. And the exemplars prior to the notification are 1, 2, 3.
Till 6.
Till 6.
What is the date of the notification?
July 1990.
So all of them are prior to that.
Prior. Well, 7 to 10 are post the notification, and that's why the
And
reference.
it is also not as if that it is for a small plot or something. It is for 96 R.
Yes, sir. 1 acre.
Well, the acquisition of MIDC is for a much larger area, and these exemplars which have been cited are for a smaller.
It's not a smaller area. It's the largest amongst all the exemplars.
Yes.
My lords, it's 96 R, whereas the acquisition is for hectares.
We know that.
My lords.
You can't have an MIDC on 1 hectare.
My lords, but the reference code has averaged the sale price as well as the averaged the sale instances and given the enhancement, my lords. That is what
It has to be on the average, or it has to be on the
my
basis
lords,
of the highest.
my lords, there are judgments of your lordship's court which say that if it is of
Unless it is shown that exemplar was malafidely done with an intention that somebody gets a higher compensation.
my lords, because out of the 10 exemplars, which were 9 exemplars which are relied, this was the only highest, and it was 2 kilometers. My lords, it was 2 kilometers away from the land acquired.
Where is the finding to that effect?
I'll show your lordship.
It's contrary.
Where is the finding to that effect? File your written submission.
My lord.
Para 29 is the findings in the reference court's order relating to the distance.
Yes.
So we'll find.
The High Court only observes that the reference court has considered. So where is the consideration by the reference court? You point out to us.
We'll do that, my lords.
When will you do that? You are supposed to do it right now. That you are not doing it.
My lords, my lords, we showed that page to your lordship's court, page 96, I believe. I'm sorry, 106. My lords, 106. Page 106. My mistake. My lords, it's already relied by the reference court.
It is read, madam, it is referred at serial number 4.
Yes.
If the learned reference court wanted to ignore it, or not taken into consideration, you should have given some reason as to why it is not found to be bona fide sell transaction. Where is the discussion to that effect?
Contrary, Your Lordship, the reference court has found it to be bona fide
Where is that?
transaction. Yes, para 30 on page 116. Last 9 lines of para 29, Your Lordship. The claimant's petitioner have placed on record the certified copies of sale deeds which have got presumptive value under section 51A of the Land Acquisition Act. After placing certified copies of the sale deeds on record by the petitioner, no rebuttal evidence has led by the respondent state. As the sale instances covered under the sale deeds are came to be effected in due course of business in routine manner between the willing purchaser and seller, therefore the transaction covered therein can be relied upon and acted upon to determine the market value of the land.
No, my lord,
And the very-
this finding is found because there were counter appeals filed by the state as well as that of the claimants.
Which were
So
disposed.
therefore, the reference code should point out as to why if the sale instance number 1, 2, 3, 5 are considered, then it shows.
The very next para, serial
My
number
lord-
4 not considered without any reasoning, Your Lordship.
Yes, my lords, 31 says that if the sale instance of serial 1, 2, 3 and 5 are considered, shows the price of land sold under sale deed was around 40,000 per acre, that is 1 lakh per hectare.
So he is claiming on the contrary 80,000 per hectare.
72,900 per acre, 1,80,000 per hectare.
To give us submissions close for order.
If other fresh matters may be listed next week or after the judgment for.
After बाकी दो इसमें issue notice returnable after 8 weeks. File your submissions by Monday.
Grateful, my lords.
Obliged.
Yeah, please. Please, your lordships, I appear for the petitioner. The parties have reached an amicable settlement, your lordships. For that reason, the TP has been rendered infructuous and we seek to withdraw.
The petitioner states that subsequent to the filing of the current petition, the matter has petition is therefore rendered infructuous before.
Grateful, your lordship.
Please, your lordship.
Yes.
It is the case where, my lords, the father sold his property and his son's property to his brother. Then after, when the son was a minor, then son after becoming major filed a suit for partition simpliciter. Then the suit was disagreed and the defendant went to appeal confirmed the suit. In second appeal, there is a reversal on finding saying that the suit for simpliciter is not maintainable. The suit to set aside the sale deed or the conveyance deed has to be there. That form of the suit should be that the conveyance deed which executed the minor's father should be set aside. Only then the partition suit is maintainable. That is the finding given by the in the second.
What was the suit for?
Suit for partition simpliciter. It is not for setting aside the conveyance deed. The court says, the trial court has held on finding on fact is that it is a void because it is not for legal necessity and not for any pious debt. So therefore it is a void. That was the finding of the trial court as well as the first appellate court. The High Court did not reverse on this finding on fact. The High Court only on the issue of law. They said that suit for simpliciter partition is not maintainable without setting aside the sale deed. My lord, my submission is.
So whether you had implicated those third parties in who?
No, third party is not here. This is the.
No.
I'm sorry.
If you are filing a suit for partition.
Yes, my lord.
In the suit, you also claim partition with regard to a property.
Please, my lord.
It is already alienated.
Please, my lord.
do you also implicate the party in whose favor the rights have been created?
Yes, my lord. Yes, my lord. My lord, in this case, the who is the receiver, that the assignee of the property is one of the co-parties. Therefore, he is not a third party, as we call it. He is the party to the partition. So therefore, it is an incidental during the partition, the court to decide the antecedent title of the property. My lord, if the suit for setting aside the sale deed is necessity only to bring back the property to the Hindu joint family to make it available for division. Supposing the property is sold within the Hindu joint family property without disturbing the sale deed, the partition can be taken place. And my lords, here what had happened in the trial court, there are two shares were sold in the deed. One is the father sold his share and the father sold his minor son's share. The court did not disturb the father's right to sell his property. The court did not disturb the father's right to sell the property. Court says that father has no right to sell the minor's property because there is no legal debt. Therefore, the partition was given. My lords may kindly consider the findings, my lords. Then, my lords, last hearing I have given the propositions.
Your father has disposed of the properties.
Sorry, I'm sorry.
The third party rights are created by your father.
I may not use the word third party. Though he is an assignee, he is a party to the suit. Third party will come only if the property goes to out of into joint family.
So in whose favor the rights have been created? In whose favor the sale is executed by your father?
My uncle, my father's brother, real brother. My lords may see the map.
Your father has created rights in favor of his brother.
Yes, brother. My lords may see this. My lords, my client name is K. Thangavelu. He is the plaintiff. His father is U. Krishnasamy. He is the defendant number 2. His brother is U. Palanisamy. On behalf of the assignment deed was executed in favor of U. Palanisamy. My client filed a suit for partition of a Hindu joint family against U. Palanisamy and U. Krishnasamy. And the court did not disturb the assignment deed, which uphold that U. Krishnasamy has a right to sell his own share, but he did not have the right to sell the property of the K. Thangavelu. That is my client's property. Therefore, there is no legal necessity to set aside the sale deed and the part. Let's I have given the proposed. Next page I have given the propositions.
Yes.
The power and authority of the father to dispose the ancestral property of his son is only to the extent of pious obligation and that benefited for the family and necessity. The disposition of ancestral property of the son by the father is to be considered as one co-partner disposing the other co-partner property, except as otherwise, other than pious obligation, and that benefited for the family and necessity, the disposition of the son's property by the father is void. When the transfer of interest in one co-partner's property to another co-partner, the Hindu joint family property is not destroyed, but it is intact. Hence, the suit for partition is maintainable without recourse to set aside the transfer deed. Where the purchaser of the co-partner interest is a stranger, it is imperative to set aside the sale for the purpose to establish that there was no severance of joint family and to restore the antecedent title, enabling to seek partition.
And what about limitation?
When there is a limitation will come only if it is avoidable. If it is a void, suit for partition is maintainable because the limitation has no role. Because suit for partition, my right is always existing.
So you are existing, but then if there is an alienation by your father, when you are minor, would you not be required to file a suit within 3 years after you attain majority?
That is only to set aside the sale deed. My lords, here, would your lordships examine? Would your lords?
Dismiss.
My lords,
Totally dishonest.
no, my lords may my lords may kindly consider. My lords may kindly. No, my lords, my share have been deprived.
Thank you.
And there are findings saying.
May it please, my lords. My lords, this is a matter that pertains to recruitment of the distinction and the difference, and I would argue discrimination between direct recruitees and promotees. Yes, this is on the- You are for certain ambulance and I am for certain.
Seeking an accommodation much.
There's 102 we are having.
Yes, much. I'm seeking an accommodation.
DP, Sangeeta and others.
Yes, much. I'm seeking an accommodation much because I'm in a special bench matter at 2 much. Specifically fixed matter.
It will take time.
Yes, much.
Yes, Lord. Settle will take 15-20 minutes. But
No.
answer.
Which special bench you are?
In code 17-301.
You are also.
Lord, I'm for the appellants.
He is for some appellants, I'm for the other appellants. We are all teachers, my lords, direct recruitees.
Judgment of reversal.
Yes.
No, it's regarding parity of payment, parity in the.
It is reversal by the division bench.
Reversal.
Yes.
Yes. Reversal of the division. Equal pay for equal work, my lords. Equal pay for equal work. Class 11 and class 12 teachers.
Class?
Class 11 and class 12.
Lord, it's like this, my lord. See, there was the state formulated a policy, my lord, by which 11th and 12th standard, my lord, the mode of recruitment for high secondary school teachers was formulated for the first time. Therefore, my lord, after some time, they implemented a policy by which it was 25% by promotion from among the teachers of the high school and 75% by direct recruitment. My lord, they also brought in 2 categories of posts by, they said HSST full-time and HSST part-time. There was an earlier judgment by which, my lord, teachers from government schools were given the benefit of parity in pay, whether they are from the 25% of.
We are part-time teachers or we are full-time teachers?
No, teachers are full-time. There was just a designation of less than 15 periods or less than 15
No, but then what has been observed by the division bench is that the part-time and the full-time, they form different classes and there can't be parity among them.
That's correct, my lord. The single judge, learned single judge goes into it in great detail and finds that going by the scheme which has been formulated by the government, there is no difference. In fact, the division bench also, my lord, in paragraph 27 says, it may be that they are doing the same work, but it is a case where the government decided that in respect of one category of employees, who came from promotees, we could not, the government decided not to go in for a reduction in salary and therefore fixed it in that way. Government also, the division bench also finds these persons who were recruited directly also do the same job. In fact, they specifically say that. But nevertheless, they can't claim parity. I'll take your lordships to the government orders. Lord, if my
He wants time. I think.
he wanted time, that's why.
When next Thursday.
Yes,
As your lords.
The evaluation is also.
Next week, my lords.
As your lords.
We'll have it after lunch. You get the report by the time. Acha.
Lordship, can I request you one read petitions is already pending before the 1 month. It is related to work board. The Lordship, they kindly give the directions because they inflict.
We'll be only following the orders which are passed by the earlier bench.
Yeah.
No new matters.
Lordship, either Lordship, they give the direction to registry, it is they treated
No,
as
we are not
IA.
giving the direction.
IA. Lordship, they give the direction to as a IA. Lordship can give me permissions to 1 minute very urgent matters which are related to my army. One particular BJP 8 times MLA, which is a cabinet minister of the state of the Madhya Pradesh, which is the abuse to the Lordships, my Colonel Sophia, Qureshi and others. He is not entire things to be completed. He is abusing by the social media platforms. His abusing statement is Lordship, I am repeating, Lordship be heard, entire court be heard, 140 crore citizens are the hearts.
Who are you?
Lordship, I am a citizen of India.
What do you want?
Lordship, I am seeking here that
What do you want?
No, Lordship, I am just seeking here that Lordship gave the permissions, direction to the central government or state government. These types of the abusing persons taking the actions, Lordship, is very necessary because Lordship,
What have you filed?
state
What have you filed?
Lordship, I am filed the letter petitions.
Letter petition.
Yes, Lordship.
On oral mentioning dismissed.
Lordship, please.
On oral mentioning dismissed.
Lordship, this statement is very important.
We don't want this publicity interest litigation.
Lordship, I am not.
We don't want this publicity interest litigation. That's all. Anybody read some newspaper item in the newspaper?
No, Lordship.
And wants to
Media,
file a
Lordship, we
petition?
also seen these videos. All ladies, all are the birds, all are the citizens are the heart, the Lordship. There is he is saying
The
that.
Madhya Pradesh High Court has already taken a cognizance,
Yes, Lordship. Yes,
passed an order. Don't file public petition only for the front pages.
Lordship, his statements can I read? Lordship, with permission. Other Lords.
Are you?
Please, Lordship, take Lordship. No, I think. Please, Lordship.
Yes.
It's, before I place the report to your lordship, the original report is also there. Would your lordships kindly see the original report in green?
Let
No problem. No, just to place the report.
Lord, may I just put it simply? Lord, the issue is this, that your lordships took a view that there is an open prison in Sanganer.
Yes, Sanganer.
Now we are concerned with Sanganer.
One of the model open.
It is the model open prison, and I must point out not three things. I'll put it. Not I'll come to the amicus's compilation and tell your lordship what there is research done on this open prison and why our case is that the land ought not to be reduced. The fact is not that there is a parcel of land. There is an additional parcel which they say they'll allot to us, but which is already under occupation, and partly in the red area also it was being used. Now the question is not twofold, and I'll put it to your lordship purely on a conceptual issue, that when we are looking at the open prison, we have to consider two things. Why was Sanganer made the way it was, and why was it? My lord, the report is there. The report is a factual report. Not I can't really protest on the report. There is a view that is taken. That is the registrar of this court has given a report. That's not the issue in context at all.
Yes.
Now, Lord, may I just request your lordship straight away?
One copy.
Would your lordship like to go through the report first?
Yes, let us go through the report and
Yes,
then
of course.
we'll consider what are your objections.
Yes, of course.
I think the report will be better understood if your lordship. I just marked one map for your lordships. It's here. The annexures are kept separately. Your lordship just opens up that map.
Yes.
There's a white flag. Let's just open
Yes.
that map if your lordships opens up. That's the area in the green millets. The green shaded area is the original allotment. Lordships will note that is 17,800 square meters. The original allotment is the green.
17,000.
800 square meters. There is no dispute about that. That the original allotment for the jail was only open prison was only 17,800 square meters. Plus organically structures the inmates of the open prison and the office spaces, schools which came around the open prison millets have traveled into the blue and the red areas. The lordships also sees the blue and red areas. What is now proposed to be given for the hospital is the red area. That area, lordships will note, millets, is 22,232.33 square meters.
22,000?
22,232.33 square meters. Plus, your lordships will also see there is a road going in between, proposed road millets between the red and the blue area. It's called a ZDP road at measuring 2,400 square meters. Let's now what the report in short says is that all the structures, the inmate structures which are there in the red portion will be shifted to the green area. That's proposed. That is the originally allotted area for the open prison. That's proposal number 1.
Blue and
but I
green
think,
both, Manoj.
but
The registrar suggests it will be
in the blue and green area.
yes.
But the registrar also gave a subsequent proposal. There are 2 proposals. And I think the second proposal is worthy of acceptance. He says what has now happened is the structures in the red, blue and green area were all shanties. No hygiene, no proper hygiene, no sanitation, etc. So the registrar's report says that in case you want to shift this, you have to build new structures in the green area anyway, blue and green area anyway. Why don't we build for everyone, not just those structures which are present? In the red area, about 111 structures are there. The total capacity of the prison is about 400. So he suggests, because all of them are dilapidated structures, in the interest of reformation also, he says that it must be a better facility for all of them. It can't be that some prisons remain shanty, some quarters are shanties and some
Article 14.
Article 14. So the second, that proposal is that in this green and red area, this portion will be used for public utilities for the prison inmates and left as an open space. In this area, construction will come up.
In which area?
There is one more map where the new outlay is there. There is one more map immediately after this. There is a proposed plan. Basically, above the road will be the hospital.
Above the proposed road.
Above the proposed road will be the hospital, That's the
Why don't you, may I just, we'll do it like this, just open it. But what my friend is saying is, this is the hospital, this is the land allotted.
We have the.
Got it. So green is what is allotted originally according to them. Blue is what they proposed to allot.
Where will they temporarily shift?
So they say only once construction starts will any demolition or shifting take place. The state has agreed to that also. The state says, that there won't be any shifting now. Only once construction starts, they will be shifted in parts. As and when the construction starts, then they will slowly shift these people out into that area. So this seems to be the proposal.
But in para 23, the learned registrar said, therefore, the complete relocation of all the structure and development of blue and green land is made.
Yes, Mr.
Now, but let me just, please have a look at, this is PDF 151 of that report. Does your lordship have PDF 151 of the report, my lord?
We don't have PDF. You tell us.
I'm sorry, Lord. I'm extremely sorry. Lord, this will be, just give me a moment.
The map, is it?
The map is what page?
See, the map is the one which is open before that.
No, the map, the court has is slightly different.
No, this map only.
But your lord, your lord.
You're wanting to refer to the report.
Yes, but there is a map, this is the map of the report. What is the page of the?
Sir, we had this opening nahi hai.
Lord, just, आपके वाला था ये. इसमें बड़ी structures नहीं है ना?
वो उनके वाले में है.
Your lordship has the structures mentioned in that map?
Yes.
That.
I'm not kindly just see. So the point is this, Lord. The green has a multiple number of structures mentioned there, and those structures are described.
You want the old map or the new map?
Not the map which is part of the report. I don't know which one your lordship has not. The old original one.
There is no map.
This one.
No, not this.
This one, that one. That's all.
Which is part of. No, not the second page. You have a. Yeah.
Sir, वही है sir. I can explain it from there. It has all the structures.
Yes.
This is the one. Explain it from here. This is the one.
There is a blue area, there is a green area.
This will do. Not this will do. I'll explain to your lordship. Not this is the one. Now, not, if you'll see, not there is a green area with a structure, let's say about 16, 1 or 19, as the case maybe is described as 61. So there are structures here. Then the area above that, which is possibly about light blue, there are a number of structures. And some of the structures in the green area will also extend into the blue area as part of the same condition. For example, I believe it's structure number 64. Structure number 64, not 64, 65. Now, keep one thing in mind, Lord. They are now proposing 2 things. And of course, in the red area, there are a number of structures. Please not consider this. This is government land, not built by the prisoners, but by the jail authorities themselves. Whatever the reason was, they built it under whatever impression. So they built it and they started occupying this entire area. Now the proposal is to on the red area, demolish those structures naturally and shift them to the blue and green area and make a road and what is more important, and this is where the point I seek to make is they want to make multi-story structures. Now there is a reason why multi-story structures, I understand for a citizen like me, it may sound natural that what is wrong with a multi-story structure, but in the concept of, in the context of victimology and prisonology, there is also study of environmental criminology, which I have sought to place as part of my written submission. And I'll put it to this way, there is, on the context of open prisons, let me just begin by saying the 3 or 4 relevant points. Let us begin with the report. First, if your lordship wants, I can read the report, which I accept as a matter of fact. I can't doubt that, but I want you to see certain annexures which are put, including the BPRD report on Sanganer by the learned amicus. And if my lord may just come to that. This report is as it is not, this is the factual position. Please come straight away to the amicus compilations.
Yes.
Number volume 1 of the amicus compilation, not the amicus, has placed a table. Just a minute.
Yeah, not this one.
Not this one.
But there are large volumes which a lot of work has been done by the learned amicus, and it's something to be appreciated. Would your lordship come to A4, page 22? Let's begin with A4, page 22. This is volume 1 of the amicus compilation. The index will begin by saying an order of this court in Honorable Court on 12th December in human conditions. Ma'am, it looks like this. See.
So this compilation on behalf of
amicus, Lord?
Yes, but page 24 begins with
Not 22, not 22.
22 number of open prisons in India.
Yes, my lord. Table showing number of open prisons. Now I want your lordship to see this for a moment, to realize, consider this, Lord, that Rajasthan is the only state at the bottom which has 1,367 prisoners. They have 3 open prisons. All the other states, it's complete underutilization. So the data from the other states is of no relevance. That's the first point made very ably by my learned friend, the amicus. Then, my lord, the next page, annexure A5 at page 24, is a report submitted by Nalsar at the request of BPR&D. BPR&D being the Bureau of Police Research and Development. It's a 22 report, annexure A5. Your lordship's got that? Please come to page 38, Lord, internal page 5 of the report. What were the objectives of the project? I'll begin with. May I place it, my lord? To analyze the functioning of open prisons in terms of reformation and rehabilitation of convicts, to evaluate educational, vocational and correctional programs in open prisons for their relevance and effectiveness, to assess the impact of open prisons on the socio-economic rehabilitation of inmates, to study.
If you see the proposal as could be found in the new map.
Yes, my lord.
It's more, it's more methodical. It provides for various facilities.
My lord, the facilities exist, and I appreciate what your lordship is saying, Lord. My lord may just consider for a moment the point I seek to make. Lord, there are 3 things then. Let me not summarize in three points. Lord, I understand what is following from your lordship. Let me summarize. I don't want to take.
At least in some good matters, there should not be opposition.
My lord, I'm not saying that. I'm just pointing out this aspect.
Quite appreciate your concern. But if you see the present status, it's all a haphazard thing. It will be more organized. Having all the facilities, have you at least gone through that map?
I've gone through the map, Lord, I've gone through the report, and that is the reason, Lord. I'll make just 3 submissions and I'll leave your Lordship with this thought, Lord. I understand what is falling from your Lordship, but please allow me a few minutes and I'll make good the submission on and show you international materials also as to why open prisons has to be meant, not the first parameter of open prisons is reduce surveillance. Today, you are putting us next to a hospital. You are going to bring it in a place where there are going to be crowds because there is a hospital. There are going to be bound to be crowds. And the report says.
The main purpose is they should be brought back into the mainstream of the society.
My lord, they are already not the. I appreciate that, but please consider, Lord, this issue of putting people in 1 BHK or rather not vertical apartments is going to have to increase surveillance, which is the one thing open prisons is anathema to open prisons. And the other issue, Lord, is we have to see it from the concept of the idea that we are trying to rehabilitate them. You put these people in a closer space, in a multi-story building, you're creating a powder cake for Lord problems. That is the submission I'm trying to make. And I'll make good that submission on international literature, which is the next to my written submissions. Please just see this, Lord. Your Lordship may just come to, as I said, Lord, I pointed out page 38, Lord. Now, please consider. Please then come to page 44.
44.
44, not para 8, third line. I'll just tell you the relevant lines. I know, I understand. I will not.
Page 44.
Same report, not page 44 of that. Para 8, third line. It says. In fact, I'll read the first 4 lines. Prisoners in Madhya Pradesh, Assam, West Bengal, Rajasthan are transferred to open prisons. They are cut off for extended duration from society, left with 3 to 5 years in open prisons. Yet in Rajasthan, their ability to find work in the market is greater than in Kerala. Then, my lord, page 72. Sorry, my lord, I'm sorry. Just a moment. Page 45, lord. Page 45, I'm sorry. Roman 3.
The recommendations.
Yes, Lord. Now, please come to Lord Roman 1, 3, Roman 1 is, of course, open prisons. Now, please come to 46, Lord, page 46, number 7. All open prisons must be independent establishments with their own budget, medical, training, marketing, council staff with.
Independent establishment does not mean that independent independent huts.
Lord, allow me 8 also, Lord. Let me read 8. I know what is falling from your Lordship, Lord. Allow me 8 also. Open prisons.
The judges in Delhi High Court, they get to live in big bungalows. But the judges in Bombay get to live, they have to live in the apartments.
I was telling my worthy friends, this is an example which I will have a very great difficulty to answer.
And in Calcutta High Court, they don't get houses at all.
Lord, can I just...
Thank you.
Lord, can I make a request then? Can I make one request? I leave it to your Lordship.
We'll say that they will strictly abide by, you give an undertaking that you will abide by the report.
Yes, Lord, I'm making
Lord,
a
just
statement. my lord.
one request, Lord, one request, and I must say this, Lord, what is going to happen is, and I'll just show your Lordship one thing on the report, which is a little troublesome, which.
But that by your analogy, we have to stop the construction of the new court complex here.
May I just?
Because here, all of this can come to the first court, 5 courts, and there you will have to use escalators and lifts. And
my lord, there's a difference between, and I'll tell you, Lord, I will only leave it as an academic thing. Just read at some point. Read the annexures to my submission.
We do not find any reason to interfere with the present contempt petition. In taking into consideration the concern expressed by the petitioner, we had ordered that it's one that directed the registrar of this court to inspect the site and submit his report. The registrar of this court has physically inspected the premises in question. The perusal of the report would reveal that the present the proposal of state government for establishment of a hospital and for modernization of the open prison is a feasible one. First, we have also perused the proposal as is approved by the government.
Yes, yes, my lord.
This is JDS.
TFI,
We also perused the proposed layout.
which is part of the last order also, my lord.
The layout.
Yes, yes.
We also perused the proposed layout. The perusal of the layout would reveal that the area between the proposed satellite hospital and the modern open prison would be divided by a ZDP 24-meter road. So just be seen that both will be the separate establishments. If the proposal is accepted, apart from providing a decent housing to the inmates, it will also provide various other recreational facilities to the inmates as well as their children. The learned AAG for the state is the learned SD and the learned AAG for the state, the learned Attorney General and the Additional Advocate General appearing on behalf of State of Rajasthan have made a categorical statement that they would abide by all the suggestions as incorporated in the report of the registrar of this court, and it is further stated that before demolishing the structures wherein the hospital is proposed to be constructed, the buildings in the open prison complex would be constructed so that no inconvenience is caused to the inmates. We find that rather than permitting we find that the proposal as proposed by the state government with the riders as given by the registrar in his report would, rather than causing any inconvenience or prejudice to the inmates, would be rather beneficial to them in as much as they would be living in the decent accommodation as compared to the shanties in which they are presently living. So, the proposal would provide a more organized open prison complex, which will, in addition to provide a decent housing facility to the inmates, also various avenues for recreation and self-development of the inmates as well as the children. The contribution is therefore dismissed.
So I just one request, Lord, that the land, Lord, today, Lord, there should be no further reduction of land because not the concern is hospital is likely to be expanded. It should not.
We find that the apprehension of the petitioner can be taken care of by directing the state that they will abide by the layout which is taken on record and marked X for identification. It is annexure H to the report.
This is annexure H, Milord. This is a layout that is given by the
Just say
JDA,
that.
Jaipur Development Authority, and Inspector General Prisons. Your Lordships will record that so that it's
Lord-
there, narrative.
And we'll strictly, we will abide by the layout, which is annexure H to the report of the commissioner, and which is a proposal prepared by the jail,
Jaipur Development Authority and the Inspector General of Prisons.
Jaipur
Para
Development
25 of the report says that. Look, there is one.
Jaipur Development Authority,
One more request.
And the Inspector General Prisons, IG Prisons.
and approved by the inspector, approved by, implemented by
They prepared this report and gave it to the court commissioner. They proposed this layout and gave it to the court commissioner. Court commissioner agreed with the layout.
As approved by the court commissioner.
This was provided to
no.
them. It is broadly the same, my lord, but once it will be contracted, there will be minor, small structural changes, my lord. That's the only request.
We direct the state government to file an undertaking of the chief secretary before this court, stating therein that the layout as prepared by the jail inspector,
JDA, Jaipur Development Authority and the Inspector General of
Authority, and as approved by
Health department is also involved.
would
the
not,
state will file, sir.
would not be altered any further. We further find that we further direct that it shall also be stated in the undertaking that except minor variations, no major variations would be done in the plan. It shall also be stated in undertaking that no further reduction of land which is proposed as per the said layout would be done in future.
Not just one last thing, Lord, I'll leave it to your lordship. Since it is an open prison, Lord, so far the surveillance has been completely minimal in terms of the requirements of open prisons. Our only concern is, and I'll leave it with the authorities of the state to ensure that that ethos and that requirement will not change merely because there is a hospital across the road.
It's not, Z security office is not coming there.
No, Lord, it's not that. No, Lord, I was not saying in that, Lord. What happens is the hospital is going to be available, as said, and they will require to have it, Lord. All I'm saying is.
On the contrary, if there is a hospital, they will come in the mainstream of the society rather than living in a.
Employment opportunity will be
But
there.
that area is actually, most of them are employed with auto rickshaws, etc. E-rickshaws is.
Auto rickshaws will be, it will be more beneficial for them. They can fly the patients there.
Lord, if they're willing to accept us, the employees will be more than happy. If the government is willing to accept us, we'll be more than happy, Lord. If the government is willing to accommodate these people to help in the medical establishment, we'll be more than happy, Lord.
But there's one request, my lord.
I'm grateful to your lordship, Lord.
Lord,
But on a separate note, your lordship had some, just see at your own convenience, make interesting reading as to environmental criminology, Lord, for another matter, because there is now this concept of environmental criminology that vertical closed structures lead to an enhancement in crime. A separate study for a separate day. I'm not pressing it, but have a look at it, Lord. Because I must tell you, Lordship, it is my master's subject to revisit it.
You will have to demolish entire Gurgaon, entire Faridabad, the entire Noida.
My Lord, may I just tell your Lordship, this whole issue, there is actually some research done that vertical structures and structures which are close by.
Everybody is not fortunate enough to have 3 houses in defense colony.
I wonder who.
We are not seeking answer.
But your lordship knows a lot more than many.
Lordship said indicate some date in a lordship consider a report for the other
We
direction.
will have it after vacation only because next day we don't know how much time work will take.
My lord.
Not this side of the vacation, definitely not this side.
You mention it after vacation. We'll take it.
My lord, only
Mention it in July.
Only one clarification, my lord. The jail authorities, my lord, gave me a call in the morning. My lord, in the report at page 34, the learned registrar has said the garden can be used not only for the inmates, but also it
That
will
is
be
a problem, Lord. That will become a.
useful for the patients of the hospital. My lord, for the security point of view, my lord, that reason may be left to the state, my lord.
I think, Lord, then you are reducing the area of the prison.
एक sentence add कर लेना. The learned counsel was a petitioner. The learned amicus as well as the learned counsel was the state agree that the suggestion as given by the registrar in his report that the garden can also be used for the persons taking treatment in the proposed hospital may not be conducive to the object behind providing, what is it called? Recreation?
Lord, recreation for open, for prisoner. Open space.
Correctional home.
Correctional home.
Open correctional home. Open prison जो यहाँ है open.
Open correctional home.
Open correctional home. Post. But in that way, we therefore direct that the the state would not be bound by the said recommendation. Further clarifies that the gardens inside the open recreational home would be used only by the inmates and their children.
Very
Grateful.
grateful, my lords.
Deeply obliged. No, I'm really grateful.
I'm obliged.
Appearing for the respondent, my lords. This case appears covered, my lords, by a 2020 judgment of the full bench of this honorable court, my lords.
I'm the appellant, my lord.
Yes, Mr. Ranjan.
My lord, your lordships have held, my lord, that the objects of the trust can be seen for registration under 12AA of the Income Tax Act. And there's no requirement that the activities of the trust should have started. Lord, that is the same question involved, my lord, in this appeal. 2020-17 SCC 254, my lord. The copy of the judgment is shared.